Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And if you need to contact me regarding your foreclosure, if you have any questions, you can send me an email. My email address is foreclosurehelp777@gmail.com. And so, as you know, I'm not an attorney and I don't give legal advice, but I do help other people that are pro se, since I fought my own foreclosure pro se. So, let's get started on today's topic, which I think everybody will find very interesting. We're gonna talk about loss mitigation today, understanding loss mitigation options before foreclosure. These are very important topics, guys. And the Bible verse of the day is Proverbs 15:22, which says, "Without counsel purposes are disappointed, but in the multitude of counselors they are established." So what is loss mitigation, right? The idea is that homeowners should understand all of their options before making any decisions. The definition of loss mitigation is, it's the process by which mortgage servicer works with a homeowner who is experiencing financial hardship to find an alternative to foreclosure. The goal is to reduce the lender's potential loss while helping the homeowner keep the home, catch up on missed payments, or exit the property in an orderly manner. Now let's talk about why lenders offer it. The goals, of course, avoid foreclosure, reduce losses, and keep borrowers in their homes when possible. Is loss mitigation required? Yes. Under federal mortgage servicing regulations, most mortgage servicers must evaluate complete loss mitigation applications and follow specific procedures before moving forward in foreclosure. Servicers generally must accept and review complete loss mitigation applications, notify borrowers if an application is incomplete, and identify what documents are missing. They must evaluate borrowers for available loss mitigation options offered by the loan owner or investor. Provide a written decision approving or denying the application. In many situations, pause certain foreclosure activities while a timely complete application is under review, often called dual tracking protections. However, a servicer is not required to offer every type of loss mitigation. A servicer is not required to approve an application if the borrower does not qualify under the investor's guidelines. Let's talk about the different types of loss mitigation. A new repayment plan, a forbearance, a loan modification, an FHA partial claim, a VA loan options, USDA programs, a deed in lieu of foreclosure, a short sale, a reinstatement, or redemption when applicable. The complete loss mitigation timeline looks like this. You missed a payment, collection calls, notice of default, loss mitigation application, complete application, servicer review, then there's a decision, then you have your appeals rights, then you might have modification trial, and then a permanent modification or foreclosure. So, what makes an application complete? Well, you must have your required documents, your income, your tax returns, your bank statements, a hardship letter, financial worksheet, authorization forms. Now let's talk about the federal law governing loss mitigation, because this is important if you're fighting against the bank and you want to file counterclaims against them. RESPA and Regulation X. The Real Estate Settlement Procedures Act, also known as RESPA, is a federal law enacted to protect homeowners during the mortgage servicing process. The Consumer Finance Protection Bureau, or CFPB, issued Regulation X, which implements RESPA's mortgage servicing rules. Think of it this way. RESPA equals the federal law passed by Congress Regulation X is the details or rules that mortgage servicers must follow. So 12 CFR 1024-41. Loss mitigation procedures. This regulation establishes how mortgage servicers must handle loss mitigation applications. Among other things, it requires servicers to accept complete applications, review all available loss mitigation options, notify borrowers if documents are missing, provide written approval or denial, explain the reason for the denial, and in many cases allow borrowers to appeal a denial. They must follow restrictions or move forward with foreclosure while a complete application is under review. Dual tracking. One of RESPA's biggest homeowner protections is against dual tracking. Dual tracking occurs when a servicer continues foreclosure while simultaneously reviewing a loss mitigation application. Federal law places significant restrictions on this practice. If a homeowner submits a complete loss mitigation application more than 37 days before a scheduled foreclosure sale, the servicer generally may not move for the foreclosure judgment, order a sale, or conduct the foreclosure sale until the application has been evaluated and the applicable review period has ended. Important rights under Regulation X. Homeowners generally have the right to submit a complete loss mitigation application, receive written notice if documents are missing, receive a written decision, know why an application was denied, appeal certain denials when applicable, be protected from certain foreclosure actions while a timely complete application is pending. So what are the common servicer mistakes here? Lost documents, repeated requests, claiming documents weren't received, failure to review, delayed decisions, incorrect income calculations, wrong investor guidelines. RESPA protections. Complete application, acknowledgement requirements, evaluation requirements, appeal rights when applicable, dual tracking restrictions, communication requirements. So, reading the denial letter, what income was calculated correctly? Were expenses correct? Was property value accurate? Was investor identified? Did the denial give a specific reason? Let's talk about trial modifications now, how they work. Payment requirements, deadlines, common pitfalls, and permanent modification. How do trial modifications work? Well, the typical process is a homeowner submits a complete loss mitigation application. The servicer reviews the financial information. If eligible, the servicer offers a trial payment plan. Borrower makes every trial payment on time. The servicer reviews the final documentation. If all requirements are met, the servicer offers a permanent loan modification. Now remember, a trial plan is not a guarantee of a permanent modification. Payment requirements. Most trial payments require every payment made on time, correct payment amount, payments received not merely mailed by the due date, continued financial eligibility, compliance with all trial plan terms. Missing one payment may result in denial of the permanent modification. So what's a permanent loan modification look like? Once all trial modifications are successfully completed, the servicer may offer a permanent loan modification, which may reduce your monthly payment, lower the interest rate, extend the loan term, capitalize certain arrears into the loan balance. In some programs, defer a portion of the principal until payoff or sale. The borrower must carefully review and sign the permanent modification agreement before it becomes effective. And what happens to the escrow? Many borrowers never understand that taxes continue, insurance continues, escrow shortages after modification, and payment changes. Fees during loss mitigation. You might be charged for attorney's fees, inspection fees, corporate advances, late fees, servicing fees. Questions homeowners should ask. Now, document everything. This is important. You want to keep your emails, your fax confirmations, your certified mail receipts, uploaded confirmations, phone logs, modification packages, denial letters, approval letters. In other words, you want to keep everything because you never know if you're going to need it in court. Questions every homeowner should ask. Who owns my loan? Who is the investor? What program am I being reviewed under? Is my application complete? When is my decision due? Can I appeal? And here's some real case studies. You have seen documents repeatedly requested, incorrect payment calculations, wrong escrow figures, servicer transfer during review, conflicting information from different representatives, borrowers approved after initially being denied, FHA loans with servicing issues, forced place insurance complicating affordability. Here's a case. Bank of New York Mellon versus Brooks. And this is a Pennsylvania case. Facts. The homeowner submitted a loss mitigation application seeking foreclosure alternatives. The servicer claimed that the application was incomplete, but failed to tell the borrower exactly what documents were missing or provide a reasonable deadline to submit them. Meanwhile, the lender continued pursuing foreclosure. Now, the Pennsylvania Superior Court reversed the lender's summary judgment. The court held that the servicer failed to comply with 12 CFR 102441 because it did not properly notify the borrower regarding alleged deficiencies in the application. Here's a key quote. Foreclosure is not permissible unless the servicer complies with this procedure. A lesson for homeowners. Servicers cannot simply reject an application without explaining what is missing. Regulation X requires proper notice and an opportunity to complete the application. Here's another case. Immigrant Savings Bank, Long Island versus Berkowitz. And this is out of Connecticut. The fact. The borrower argued that the lender violated federal dual tracking rules by continuing foreclosure while loss mitigation application was pending. The court examined the requirements of 12 CFR 102441G, holding, although the borrower ultimately did not prevail because procedural issues, the court recognized and discussed the protections created by Regulation X. The decision reinforces that a servicer generally may not conduct a foreclosure sale when a complete loss mitigation application is timely submitted. And this key regulation says if a borrower submits a complete loss mitigation application more than 37 days before a foreclosure sale, a servicer shall not conduct a foreclosure sale. Lesson for homeowners. Timing matters. A complete application submitted before the regulatory deadline can trigger important federal protections. Borrowers must always follow all procedural requirements to preserve those rights. Why these cases matter? These cases demonstrate that Regulation X has a real legal force. Servicers must follow federal loss mitigation procedures. Courts can reverse foreclosure judgments when servicers violate Regulation X, and homeowners should carefully document every submission and every communication with the servicer. Loss mitigation isn't just paperwork, it's a process with deadlines, documentation requirements, and rights that homeowners should understand. Staying organized, keeping copies of everything, and asking informed questions can make a significant difference in navigating that process. Okay guys, I hope this was informative to a lot of y'all out there facing foreclosure. And if you have any questions, you can always leave them in the comment section below, or you can email me at foreclosurehelp777@gmail.com. And I hope everyone has a blessed day.